The reach of the law permeates all aspects of our daily life. Post-secondary institutions do not escape it. Law's presence is both pervasive and inescapable. Post-secondary institutions are constantly subject to litigation, government regulation, and oversight. For them, law is an inescapable consideration. For example, institutions must adequately respond to a student suing for mandatory student fee allocations, failures of campus security, etc. Similarly, a faculty member may seek legal redress over salary decisions or sue for tenure, which is very common, by the way. Outsiders to an institution may also involve colleges and universities in liability. They can be taxpayers, fraternities, and more. However, litigation is not the only solution to resolve a dispute. ADR, or alternative dispute resolution, has become a more efficient and less costly way of resolving disputes. ADR has become prevalent in many areas like corporate, government, etc. Post-secondary institutions have been catching up to alternative means to resolve dispute and avoid litigation. ADR has helped ameliorate the negative aspects of the law on campus. How are post-secondary institutions governed? Where did their authority come from? Who is subject to this authority? Governance refers to the structures and processes by which higher education and systems are governed in their day-to-day operations and longer-range policymaking. Governance varies greatly depending if an institution is public or private. This is because they are created differently. If an institution is public, they are heavily subjected to federal and state constitutions and the Rights Clause. Governance structure and processes provides a framework where problems and disputes arise, but also the framework to resolve these disputes. Disputes within this governance framework may generate a legal dispute that could end up in court. Governance is divided in internal governance and external governance. In brief, internal governance is how institutions govern themselves, and external governance is how outside entities play a role. Internal governance relies on internal sources of law, while external governance on external sources. What are these external sources? They are public external governance and private external governance. Public external governance for post-secondary institutions is comprised of several participants, which include federal government, state government, local government. Federal government has limited power over education. This is left to state government. However, it does exercise substantial governance authority over public and private institutions. For example, institutions must abide by federal regulations in order to be able to receive federal funds for financial aid, for example. Also, the federal government, through the Department of Education, authorize accrediting agencies, which in turn accredit post-secondary institutions. This institutional accreditation allows institutions to receive federal funds. Another example is FERPA. FERPA is the Family Education Rights and Privacy Act. Under this act, post-secondary institutions must protect the right of privacy regarding grades, enrollment, billing information, and more of their students. This is a federal law. There are other areas such as federal disability, racial and ethnic diversity regulations where the federal government influences post-secondary institutions. State government. There is a very important distinction between the influence of federal government and state government. Unlike federal government, state government influence varies depending on whether an institution is public or private. Public institutions are subject to a greater amount of oversight by the state government. State government has authority over education through its constitution. It can create, organize, support, and even dissolve public higher educational institutions. For private post-secondary institutions, they're subject to state government as well, as they must seek permission in order to be able to offer degrees and operate as an institution in the state. The responsibility over ensuring state oversight over post-secondary institutions and their compliance with relevant state regulations rely on state government, agencies, or university systems or a board of regents. It varies. For example, in Minnesota, this responsibility falls on MOHE, the Minnesota Office of Higher Education. In Louisiana, it is the Louisiana Board of Regents. And in North Carolina, the University of North Carolina Board of Governors. It depends on each state and their own regulations on this matter. Some of them have great oversight on licensing private post-secondary institutions, and some of them really minimal. Regarding local government, they also exercise an influence over post-secondary institutions, especially over community colleges. Institutions must comply with local ordinances such as building codes, traffic laws, and other laws that may affect the institution. Private external governance. The most common of external governance are those exercised by accrediting agencies. As I mentioned earlier, accrediting agencies must be authorized by the U.S. Department of Education. Institutions seeking to receive federal funds must first obtain institutional accreditation. By doing so, they are scrutinized, thoroughly evaluated by these agencies, that in turn must affirm that the post-secondary institution serves a legitimate educational purpose and it is fit to offer degrees. In addition to institutional accreditation, most universities seek programmatic accreditation. For example, an institution may pursue programmatic accreditation from an accreditor for a specific program. The institution would then comply with the various requirements imposed by the accreditor in order to accomplish and maintain this accreditation. This accreditation process may entail site visits, interviews with faculty, students, and staff involved in these programs. The accreditor may require for the institution to fulfill a set of recommendations in order to approve. These recommendations may go from expanding faculty members in the programs, expanding library hours, changing procedures, or any other requirements they may require to be able to approve. Both forms of external governance greatly influence institutions' decision-making and processes. Moving into the area of internal governance, the best manner to explain is to think about it as internal law. How does the institution govern itself? How must it be governed? Internal law is delegated to institutional officers and it delineates the rights and responsibilities of individual members of the campus community. It is very important to mention that external law that we just covered always takes precedence over internal law. Universities are typically governed by a governing board, board of regents, or board of trustees. Universities have different hierarchical organizations, but usually there is a president or chief executive officer, followed by chief academic officer, who typically oversees all the academic functions, including deans of each school, legal counsel role, chief information officer, chief operations officer, the offices of admission, financial aid, registrar, student services are also included as part of an academic organization. However, as you can see in the slide, this is just an example. Universities can be organized in a variety of ways, but there's always a hierarchy. Institutions have the authority to self-regulate by promulgating its own institutional rules and regulations. However, they must never contradict external sources of law. External sources of law will always prevail. In addition, institutions possess contractual relationships with its faculty, staff, students, and outside parties which are always interpreted as common law. For post-secondary institutions, academic custom and usage is tremendously relevant and applicable. These are considered to be the practices and understandings within an institution. Academic custom and usage are also referred to as campus common law, and they stem from informal practices, memos, policy statements, from speeches, and more. This is a very important guide for decision making, as it helps to clarify ambiguity such as contracts that may not be clear between faculty, staff, students. Legal liability. This governance framework, both internal and external, can generate legal liability. Legal liability can come from three different sources: constitutions, state or federal, statutes and regulations, and state common law. There are two types of liability: corporate or institutional, and individual or personal. In exploring legal liability, it is important to talk about agency law. Can the actions of a university employee make the university liable for them? What if it happened outside the campus? Courts more commonly assign responsibility to the university if the employee was acting within the scope of employment. How to determine if an action happens within the scope of employment? It is not clear-cut sometimes. What if the employee committed an illegal act attending a conference where he is representing the university? It appears the university may be liable. However, what if the illegal act happened outside the conference environment at a private venue and no university business was being conducted? Then the university shouldn't be held responsible. However, as I mentioned, to determine responsibility is not as clear-cut. Preventive law, avoiding legal liability. Today, universities are being more thoughtful and intentional in finding ways to avoid legal liability. The most common way is to invest in sound legal planning. Legal planning allows an institution to identify and assess legal risk, determine legal risk and exposure. Institutions must ask themselves the amount of risk they can assume and whether it is compatible with the institution's mission. A successful legal planning must carefully sort out legal and policy issues. Many institutions employ legal counsel to counsel the institution on these matters. This role will definitely represent the institution when facing litigation, but as importantly, it will advise the university in ways to avoid legal liability. Sound legal planning will influence how faculty, staff, and student handbooks are drafted and updated, learner grievances, and such. Policies and responses to complaints must follow guidelines to avoid the risk of liability. Sometimes liability cannot be avoided, and universities must go through the path of the court system. Court litigation is a costless means of dispute resolution. This is why it must be avoided with careful preventive planning. As I mentioned earlier, alternative dispute resolution is a more efficient and fastest manner to avoid the court system. The two most common forms of dispute resolution employed by post-secondary institutions are mediation and arbitration. Some institutions rely on an ombudsperson, which is a very confidential, informal means to handle and hopefully resolve a dispute. This role has become very popular on many campuses, as it can be employed by faculty, staff, and students, and there is no official record on the matter. A formal way of resolving a dispute is going through a university grievance procedure. This alternative is more formal, as several steps must be followed and records are kept. These records can be used in court if a party is not satisfied with the resolution. In addition, arbitration is employed as another alternative dispute resolution avenue. In fact, some universities include an arbitration clause in student enrollment agreements and it is employed to resolve faculty issues.